All right. You've joined us for Chicago Title proudly presents Understanding the Preliminary Report. Quick commercial. When you have transactions with us, one of the options available for you to have your buyer's earnest money deposit deposited is remotely with our Start in Here mobile deposit. We also offer a digital opening package that's extremely secure for your buyers and sellers. And Darrin will tell you the importance of getting that information to your escrow and title team quickly so that we can get to work on any obstacles to closing. And for real estate agents only, but hopefully soon for consumers by the end of 2023, we offer In Here, which is a window into your transactions to see what's going on, receive messages, and get documents. So without further ado, I'm going to turn it over to Darrin to share his title knowledge with us. Take it away, Darrin.
Well, first of all, top of the morning to everybody. Thank you so much for joining us. We're going to be discussing what is the preliminary report. The preliminary report is an offer to issue a policy of title insurance covering a particular state or interest in land subject to stated exceptions. So in a nutshell, what the preliminary report does is it's a report that we issue prior to the final product, which would be a policy of title insurance. May it be a owner's policy or a lender's policy. What this report is doing is it is showing things that we are not, again, we are not willing to insure against. And the reason for that is on the preliminary report, we're going to show items that we found of public record. Understanding that as a title insurance company, what our primary responsibility is to search the public record and compile a report to let the buyer or the lender know exactly what issues we find on the property. Please remember when you're looking at a preliminary title report that it's going to be shown, the exceptions are shown in a recorded order of how they affect the property. As you can tell, Linda is, rolling through some of the basic information about a preliminary title report. I'm not going to sit here and read to you every line on this. Again, when you have time, go back and take a look at it. And, it really is self-explanatory. So let's get right into the prelim, Linda. Let's go ahead and click it over.
It's Jennifer being your person there.
Oh, I'm sorry,
yeah,
Jennifer.
You're good.
Yes,
I'm
sorry. I thought you were both co-hosting, so I didn't know who was turning the pages. So key items to look for in your preliminary report. Your name on the title, number one. Is your name reflected appropriately on the preliminary report? How do you, as the buyer, would you take title as Jane Doe versus Jane T. Doe? So what this report does, it's going to list exactly how you hold the physical title, the fee title of the property. It's also going to show liens, restrictions, types of liens we'll kind of get into towards the end of the class. Restrictions, there are easements, covenants, and other restrictions on a report that can impact the way that you, the buyer, intend to use the property. And as we go through the individual items in the report, I'll kind of stop and talk about how they affect the property and why it may be an issue for a buyer down the road. Go ahead and turn the page, Jennifer. Well, there are lots of pages. Okay, there's two types of title policy to be issued at the close of escrow. Typically, when you have a, let's say a new couple, married couple, and they're buying their first property, they're going to be receiving an owner's policy of title insurance. Typically, that's paid for by the seller. And what it does is it protects the new incoming homeowner for certain items. It talks about the vesting, how they're going to hold title and so forth. So an owner's policy is usually issued the amount of the real estate purchase. Let's say the transaction's $400,000 and the owner's policy would be for $400,000. A lot of times, most people have to borrow money from institutional lenders or other individuals to purchase the property. They're going to be receiving some type of lender's policy. Most all lenders require a title insurance policy in order to loan money to the buyer. So this is something that is very common, that they will have an owner's and a lender's title policy. Typically, the lender's title policy will be paid for by the buyer, as set forth by the lender as one of the requirements. Matters that are shown on the report are as follows: the estate or interest covered, in which that would be is, how do you hold title? Is it fee or is it a leasehold interest? It's going to show the owner of the estate of interest. It's going to show the parcel of the land involved, the exceptions, liens, encumbrances, and other risks which we will not insure against if a title policy is issued. And it's also going to show other requirements and provisions which are reflected as notes in the preliminary report, which are removed when a title policy is issued. And we'll kind of go through these items as we go through the actual report. It's also going to have an assessor's parcel map attached to it. The assessor's parcel map is a map that is done by the county assessor's office, showing the dimensions of the property. Understand that assessor's parcel map is not an insured map. It's just something that we provide as really a, we just provide it so you can kind of take a look at what the property looks like dimension wise, but it's not insured. Okay, the preliminary title report. This page right here is very explanatory. If you ever really want to know what the prelim does, read this first page. This is going to be something that really explains exactly how the report's going to be, what it does and why we issue it. Okay, so now the overview of the preliminary report. So at the very top left, you'll see the title officer, their email address, phone number, fax, and the actual title order number. Sometimes the escrow number and the title number do not match, so don't let that throw you off. On the right-hand side will be the escrow officer, their email address, their phone number, fax, and their escrow number. In this particular case, let's say the escrow officer is in Fresno and the property is in Tulare County. So the escrow number for the escrow officer will be that 201 number, and then the title number, which is different because it's in a county next to it, will be a little bit different. Right under that, you can have the property address. Most properties are opened by physical address on your PSAs or purchase sale agreements, sometimes assessor's parcel numbers of its vacant land. But what that is and what you want to look at when you receive that preliminary report is you want to make sure that that address right there is how you opened up the property. So we make sure that we have the correct property being in the search exam process. Right under that, you have the effective date. We use a plant system. Anytime a document is recorded in the county, it is grabbed by our company, put into a database, and that is our actually effective date. So don't let that concern you if the date is a little bit behind the actual date. So today is March 16th. Typically, our plant runs about a week and a half behind, depending on the county. So that date would probably be a little bit earlier. Let's say it would be March 25th of this year. So it runs about a week and a half behind. Don't let that concern you though, because once we go to close the file, we will continuously update that report and date it down up until the minute it records. So that date is fluent and it will change. That way we can make sure and we're catching any type of encumbrance or lien that might have recorded between the date that we issued the preliminary report and the actual recording or closing date of the escrow. Under there, you have the types of policies to be issued, the form of title policies. You have the Alta homeowners policy in this particular case, as well as the Alta loan policy. So it's just telling everybody these are the two policies that are contemplated to be issued once the escrow closes and we issue our final policy. Right under there, you have the estate or interest. In this particular case is a fee. A fee is the absolute ownership of the interest of the property. That's exactly what you want to see there. Why does that become important? Let's say that you are an agent and somebody's contacted you to list their property and they want to sell the property, and you get the preliminary title report. It doesn't say fee there, it says a leasehold. Well, you may want to start asking some questions, because a leasehold is just the sale of the building and not the property. So, or leasing the farmland and not actual conveyance of fee. Most of the reports that you guys are going to see, unless you're doing leasehold transactions, will be a fee, and that's the best way to hold title. Right under there, section 2, it says title to said estate or interest and the date herein is vested in. This is what we show at the time that we wrote the report, who the vested owner of this property is. Now, why does that become important for you to take a look at? Again, let's go back to the scenario where you're the listing agent and somebody's contacted you to sell the property. You order the preliminary title report from Chicago Title Company, and the report comes back with somebody else's name and not the name of the person that entered into the purchase sale agreement. Well, you need to start asking some questions. Because, you know, our vesting shows one person, but your seller is another. And there may be a legitimate reason why that is. Maybe it was mom and dad's property, and maybe they're incapacitated, or maybe they've passed away, and you're going to be coming into title through some type of decree of distribution or conveyance of some sort. But it's very important that you look at that and that it coincides with who your seller is. Now, if you're the buyer's agent, the reason that you want to pay attention to that is because you want to make sure that the proper parties are joining into this purchase sale agreement, and you have the correct seller selling the interest to your buyer. So if something else pops up there than what you think should be there, you know, that's when you may want to contact your escrow officer and just get a little bit more information. Right under there is a section of land referred to this report is described as follows. All property throughout the nation is described by legal description. This is how we insure it. We don't insure it as to address. We don't insure it as to assessor's parcel number. We insure it as the physical legal description of the property. In this case, this is a lot and tract subdivision. As you can tell, this is down in Southern California, this report, but if it was in Fresno, it'd be lot 58 of tract in the city of Fresno, county of Fresno, state of California. Most of the transactions you'll be doing, you know, for single family homes are probably going to be a lot and tract subdivision, but there are cases where that you will have sectional legal descriptions, which is a meets and bound legal description. Don't let that throw you off if you're dealing with ag property or you're dealing with property in the mountains. You're probably going to have a meets and bound legal description there instead of something like a lot and tract subdivision. Go ahead and turn the page, Jennifer. Again, this is just what we kind of went through. You can click through that, Jen. I think I was going faster than Jen's little fingers could go. Okay, so number one, taxes. Earlier, I mentioned that as a title company on a preliminary title report, we show the items and how they affect the property by recording order or priority. In this particular case, you can see that item number 1 is taxes. This is an older report. This shows item number 1 is going to show taxes in this particular case for next year, 2023, 2024 tax year. We're going to exclude that from coverage. We're just letting you know that taxes will be coming out next year on this property. And then section 2, go ahead and click, Jen. These show the current tax amounts. Well, why do we show these amounts first? And it's very simple, is because the county of Fresno gets their money first, period. I don't care, you have a $3 million deed of trust on this property. You don't pay your county taxes for 5 years, they will sell your property at a tax sale. And it tends to wipe out all money encumbrances. So you'll probably notice that a lot of times lenders require impound accounts where they're paying the taxes. And the reason they do that is simply so they have control to make sure that those taxes are getting paid, because they're really aware of the fact that if you don't pay your taxes, then the county will sell the property and wipe out their deed of trust, and they have no recourse. So we list them as item number 2 because they get their money first. Next one would be section 3. This is showing past due amounts. They haven't paid their taxes in this particular case. So what we're doing is we're showing the amounts to pay through a couple of months, giving you time during the escrow. In this particular case, it was $4,000 by April, let's say, of 2023, and then $4,100 by May of 2023. So this is notifying everybody that the taxes haven't been paid and that they need to be paid. Now, as a title insurance company, we don't require the taxes to be paid. What we can do is we can show them on our final form of policy of title insurance as an exclusion from coverage. But as a buyer, you certainly would not want to acquire a piece of property where the taxes are delinquent, because once you purchase the property, you're then responsible for paying those taxes. And most lenders aren't going to loan when you have property that is tax defaulted. They're going to require those be paid. Item 4, this is supplemental taxes. And so what this more or less does is during the course of the year, the county assessor only taxes or sends out the tax bill once a year. But they want to make sure that they're able to, let's say you're buying a piece of property within the year, they want to be able to tax you, right? Or you're building a pool, or you're adding an add-on, which is increasing the value of your property. So during the course of that, the county will, through the course of the year, send you a supplemental tax bill. So we're just stating that, there's going to be a supplemental tax bill coming to you once you purchase the property. Because again, the county only does the tax bills once a year. They send them out, but they will hit you with a supplemental bill. These are Melrose taxes. There are some Melrose in Fresno and Clovis area. So it shows the property is within the district within the Melrose taxes, which are included in the annual tax bill. Also states that these can be stripped from the taxes and foreclosed upon after your failure to pay said taxes. So in this particular case, this Melrose is included in the county taxes shown as item number 2. But if you default your county taxes and there is a Melrose, they can also foreclose on you. Thus, the reason these are shown as items 2, 3, and 4, because again, remember, they get their money first before anybody else. Item 6, these are covenants, conditions, and restrictions. Most properties, but not all properties, have some type of restriction on it. Well, why does this become important? I think it's very important that your buyers are aware of these, that they read them. In fact, they have to read them and acknowledge them, that they have read them and they understand them, because it can have, it can determine what you can and can't do on the property. It may have built-in restrictions that you can't paint your house blue, that you can only use certain colors, that you can't park your RV out front, that you can't have chickens, you can't have goats, you can only have 2 dogs. It could be many different things. So that is the covenants, conditions, and restrictions. It's very important that when you're presenting these to your buyer, that you make sure that they read those. And we can always give copies of all these documents to you and your customers so they can read and understand them at no charge. In this particular case, those restrictions were then modified at a later date. And that's also very common where they may modify it to take some things out or to some add things in. Item 7 and 8, these are easements. So item number 7 is a public utilities easement. You know, most properties, you have power, you have telephone, you have cable, you have water lines, sewer, and so forth. So that's what these items are. Items 7 and 8 are, in this particular case, public utility easements. It could be for PG&E, it could be for water or sewer. So it's telling you exactly where it's located on the property. So why does this become important? So let's have a scenario. So let's say you have a new married couple buying their first home, and they've come over and they've looked at that property 9, 10, 11, 12 different times. The wife wants to keep coming by looking at it because if she's anything like my wife, she has a plan exactly where she's going to put everything. She's going to build her barbecue over here. She's going to put the spa over here, and she's going to put her pool over here. Now, this becomes very important because once she goes to get a permit to put the pool in, she goes down, she applies for the permit, and the city or county denies the permit and says, no, you can't build a pool. And she's like, well, why? Well, there's a public utilities gas line that runs right where she wants to put the pool, and therefore she can't dig. Well, she's going to get very upset. And who she's going to come yell at? The first person she's going to come yell at is the real estate agent, right? And the real estate agent is going to turn around and call the escrow officer, who's going to turn around and call the title officer. And the title officer is going to look at the report and go, well, we told you about that easement. It's items number 7 or 8 of your preliminary title report. You signed the report understanding that, you know, these are the exceptions we're not going to cover. So you have no claim for on the title insurance company. So it's very important to look at those easements and make sure that you understand where they are on the property in case you have any type of plans for the property, building a pool, a gazebo, things of that nature. So be very careful of those easements. Those easements also may be for ingress and egress if you're dealing with property up in the mountain areas or in the country. You may have an easement across your property allowing your neighbor to traverse your property in order to get to theirs. So that is something else that you may want to consider and make sure the buyer is aware of, because we get a lot of calls about people who purchase property up in the hills and they say, well, there's some guy driving 40 miles an hour down this dirt road and it's dust is everywhere and he shouldn't have a right to do that. And then we'll look at it and say, well, he does have a right to traverse that property for ingress and egress per a recorded easement of record allowing him to do that. So it becomes very contentious with your neighbors sometimes. So make sure you're reading those and understanding where those easements are, so you can avoid any problems going down the road. The next item is a deed of trust. This indicates a voluntary encumbrance. So there's voluntary and involuntary encumbrances. A voluntary encumbrance would be such as this, a deed of trust where you purposely entered into an agreement with the lender to borrow money to purchase the home. They've used the home as collateral, and you've signed that deed of trust, acknowledging the fact that you've entered into this contract with the lender. That is a voluntary encumbrance. Now, an involuntary lien would be something as a child support judgment against you, if you're the seller, a tax lien, a state tax lien, a county tax lien, things that are attaching to your property, but you didn't want them to be, and you didn't sign for them to be on your property. Understand in the state of California, if you are a homeowner and you own real estate property, if anybody records a judgment against you, it automatically attaches to any and all property you own within that county. So if you own 5 pieces of property and the federal government records a federal tax lien against you, it automatically attaches to all 5 of those properties. And most of the times we're going to require that those be paid prior to the conveyance of the property to the buyer. Again, as a title company, we don't require that because we can show that as an exception to the owner's policy. But as you can understand, if you are a buyer, you would not want to take them subject to somebody else's lien because they can be foreclosed and they can take the property or force you to sell the property to pay the debt. So that would be an involuntary lien that could attach to your property. Solar energy system contracts. I'm by trade a commercial title officer, so we don't have to deal with this very much on the commercial side, but on the residential side, as you know, living in the valley, we get lots and lots of sunshine. So solar energy systems are very, very popular. You enter into a contract with a solar provider who will install the panels. You enter into a contract that you will pay them for those panels, and typically, you pay through, just like a deed of trust, through a certain amount of time, depending on what the contract is. So what we are doing here is we are letting you know that there is a solar energy system on the property, and that you are subject to that contract. Item number 11 would be the financing statement, somewhat like a deed of trust. The company that's installing the solar is going to have you execute a financing statement showing that their equipment's on your property and that you owe them money. So that's exactly what that solar financing statement does. Item 12 and 13. This is for, if you noticed at the very beginning of this property was vested in a trust. And there's many, many different ways to hold title. Husband and wife as joint tenants, an unmarried man, a married man as a sole and separate property, a husband and wife as community property with the right of survivorship. And in this particular case, this was vested in a trust. Well, what it does is, again, I'm not an accountant or attorney, but what the more or less people do to put it in a trust is it avoids probate. It avoids having to, once you pass away, enter in, go into court and having the court determine who the property should go to. So a trust itself cannot hold title, but as trustees of a trust, you can certainly hold the title. So what this requirement is this property was vested in a trust. We're asking for certain things to look at to make sure that we have the proper trustee signing for the trust. And if somebody has passed away in the trust, that we have the proper parties that will be the successor trustee that will have the authority to sign for the trust to convey the property out. As you can tell, item 13 says the company will require a full copy of the trust agreement and any amendments thereto. The reason we ask for that is because typically in most trusts, you're going to have who the actual trustees are. So let's say in this particular case, it was Linda Federico Johnson and Delilah Mendoza as trustees of the Darrin Nichols 1999 Family Trust. So them as trustees are holding the property in trust for Darrin Nichols family. Now, if Linda or Delilah, one of them pass away or resign, then we got to make sure that we see who the trust name as the successor trustee. And then the only way we can do that is to look at the actual trust agreement and see who they named as the successor trustee. Once we've determined that, then we know who the parties are that should be signing the conveyance, the grant deed out to the buyer. As you can read, it's this statement wherein it specifies that because the ownership is in a trust, it must be reviewed for insurability, and a copy of the trust, including amendments and a trust certification, will be required. What the trust certification does is after we've reviewed it and we make a determination who that is that should be signing it, we are going to ask those trustees to sign a trust certification for our company, stating that they have the right to sign for the trust and they've done everything for tax purposes and that they'll be the one dispersing the money to the beneficiaries of the trust. Because you have to remember that if a trust is in title, once it closes, the funds from escrow go back to the trust. not the individuals. Then it's up to the trustees to make sure that they are dispersing the funds to the beneficiary of the trust as disclosed by the trust itself. That is not up for us as a title company to do. Again, the monies will go back to the trust. So make sure if you have a trust that you have a bank account open in that trust name, because when that check comes from Chicago Title, those proceeds for the sale come back to you, and you go down the bank and you don't have an account for that trust, the bank's going to refuse to deposit that check. And that happens quite a bit. So make sure, if your seller has a trust, you want to advise them that, make sure you have a bank account open under that trust name, that they can deposit the proceeds in once the file closes. And then we come to the notes sections. I'm not going to bore you with reading all these notes, but as you can tell, note number 1 talks about how, as a company, even though it's legal in the state of California, marijuana is still illegal federally. So we will not participate in any closings that have to do with the manufacture, the sale of marijuana. May it be a grow facility or a facility where they actually sell marijuana for recreational or medical purposes. Note number 2 just talks about if a county recorder, title company, escrow company, real estate broker, and it just talks about California laws require the documents provided shall include a statement regarding the unlawful restrictions. Talks about how they have to have it printed. Note number 3 has to do with issuing of checks, wire transfers. So when you're looking at this, you can read through all the notes on your own time. But note number 5, I think, is important. Note number 5 is really designed for lenders, because a lot of times lenders want to make sure you're not just flipping property. So this shows that there's been no conveyance affecting said land within 24 months. It's a little chain of title. If there was deeds within those timeframes, we would actually list each deed that recorded for the past 2 years on that line. Note number 6 is again for the lender. Most lenders require that we issue a 116 or an alternate endorsement showing what the physical address of the property is at the time that they close. They use that for foreclosure purposes. If they ever have to foreclose and they have to notify people, they notify them by that address as well as the legal description. Note number 7, it says this company is not aware of any matters which would not decline to issue that endorsement. And again, it's a 116 endorsement, and we're showing what the physical address of the property is for that lender's policy. Notes 8 and 9 go on and talk about other items. And again, I'm not going to bore you with it. Why is it important to look at the notes section? A lot of times if we run into any problems, we're going to show them on the preliminary title report. So in the notes section, maybe if you have a buyer that has a judgment or a lien against them, it may be shown in that notes section. Since they're not the physical owner of the property, we don't show it in the Schedule B Part 1 section, because that has to do with what affects the property. The lien would not affect the property until that party comes into physical title. So we show it in the notes section. So when you're looking at a preliminary report, and Jen, if you want to go back to page 1, the vesting page. So under where we show the vested owner, a lot of times when we're searching and examining the property, if we've run into any problems with the vesting, maybe the legal description was bad on the deed or the wrong people are conveying property, we'll make this vesting subject to an item. So in this case, let's say it was John Jones and Linda Jones, trustees of the Jones Family Trust, dated January 15th, 2010. And then we might put a little blurb under there, subject to item number, let's say 13 of the preliminary title report. So then you would look at item number 13 and we'll have a little synopsis of what we find wrong with the deed and why and what we were required to fix it. So let's say it had the wrong legal description. We may say subject to item number 13, and then item number 13 would say something to the effect of we require this deed be re-recorded to correct the legal description because there was an error in it, and we typically try to spell it out. If we're not passing on a deed, sometimes within 2 years, we want to make sure we're looking for fraud. And you'd be very interested to know most fraud on real estate transactions are perpetrated by family members. Maybe it's mom and dad's property and they're elderly and they really can't sign for themselves. So somebody forges their name and conveys the property. Well, if we pick up that deed and it doesn't look right to us, we may make that vesting subject to that the requirement that the actual fee owner come in and execute an affidavit attesting to the fact that they're aware that they've conveyed the property to another party. We do that to try to catch forgeries. It's not to say that all transactions are forgeries when you kind of run across things like that, but it does make people aware because there is a lot of elder abuse going on right now, where people are stealing their parents or their grandparents' property and selling it out from under them without their knowledge. So that's just our way of catching that. So if you do see something in the vesting where it says subject to, feel free to contact the title officer or your escrow officer, ask us what's going on and what they can do to remedy that situation. Also on the report, you're going to have an assessor's parcel map. The assessor's parcel map is shown here. As you can tell by the little arrow, we're pointing to the property on the assessor's map. Again, this is not an insured map. This is a map issued by the county for taxing purposes only. We provide it just as an accommodation because a lot of people like to see exactly what it looks like, its footprint on the ground. The very easy way to read those is the map book and page numbers in the top right-hand corner. As you can see, there's a disclaimer on this map because we're just letting everybody know this is not a survey. This is not a legal surveyed parcel map where, all the dimensions are perfectly aligned. There may be omissions one way or the other, but again, we provide it just so you can have a kind of a look of what it looks like on the ground. Next to that, you have the subdivision recorded map book and page. Anytime a map is recorded, I don't care if it's a tract map, a parcel map, a record or survey map, it's going to receive a map book and page. In this particular case, it's, book 56, page 52, record of survey maps. So that's just a quick little way to look at it. Again, you will find that in your legal description. Where the legal description of the property is going to have the book and page of the actual recorded map itself. And we can provide you copies of those recorded maps. Most of all of our reports go out as e-pres, which means that every document that we're showing, assessor's map, vesting deed, will be linked to the report. So all you have to do as an agent or a buyer or a seller is click on that link and a copy of that recorded document will automatically pop up so you can kind of look at it and read it. Sometimes the documents are not accessible for us to link. We'd have to physically get them from the recorder's office. This happens when the document quality is not really good. A lot of times you got to understand that we search back to the beginning of time in theory. So from the time that the Spanish land grants held the property and we chase it all the way forward through time to the current owner of the property. And some of those documents are very poor quality, as you can imagine. So sometimes we have to obtain them through the actual recorder's office in order to get a more legible copy. This talks about the Alta homeowner's title insurance policy. There are many title issues that could cause an owner to lose their property or a lender loss of a mortgage investment. Even the most in-depth search of public records performed by the most experienced title professions me, must not disclose, may not disclose the most dangerous threat, hidden risk. There are risks may not be uncovered until years later. Alta homeowners policy covers forgeries, things of that nature that happen post-close. It's a great policy to get issued to you as a buyer. With an Alta homeowners title insurance policy issued by Chicago Title, the ownership to the title of the home can be protected. Here are just a few of the most common hidden risks that can cause a loss or title or create an encumbrance on title. False impersonation of the true owner of the property. Kind of talked a little bit about that. Somebody acting like they're you and selling the property and having the funds deposited into an account, stealing your property in essence. Forged deeds, releases, or wills. We look at all the deeds that record and make sure that the parties signing them are the proper parties. Typically, we'll compare the signature on a grant deed to a known deed of trust where that party was actually borrowed the money and they signed the deed of trust. And so we compare those. Be surprised how much we find there. A lot of times, a lot of people will have a deed of trust on their property, let's say for 500,000, and they'll forge a release, a reconveyance, and record it of record. What we do in that case is all releases that are recorded, we will contact those lenders and make sure that, in fact, they did record that release and they know that they released their interest. Undisclosed or missing heirs. That's one of the things that we cover in the title insurance policy. If we search the title and we make a determination of who we believe owns the property, and maybe we missed as a company somebody's ownership in that property, we allow the transaction to close. We issue a homeowner's policy to the buyer, and then a year later, somebody pops up and goes, "Hey, I own portion of that property. Here's my deed, and I never did the deed out to this new buyer." So that is something that, as a company, we would protect you against. Instruments executed under invalid or expired power of attorneys. You'd be surprised how many people try to use power of attorneys. It's very interesting to me that you could be in the middle of a transaction, maybe you're selling your property or a commercial property, and oh yeah, by the way, I'm going to Israel during the course of the transaction, and I want my brother-in-law to be able to sign for me. So I'm giving him a power of attorney to do that, which is, acceptable. We could do it in some instances. It just depends. The power of attorney would have to be executed, recorded of record. It can't be too old. So you can't use a power of attorney that's 15, 20 years old. It would have to be very recent in order for that to happen. But a lot of times what people will do in elder abuse is they'll get mom or dad who's elderly to sign a power of attorney to them. And then they'll use that power of attorney to actually turn around and sell mom and dad's property out from under them. So, there's a lot of caveats and things that can happen with power of attorneys that, as a title company, we tend to look at very closely. So if you're using a power of attorney, make sure that you are contacting your escrow officer to let them know that you're contemplating use of power of attorney. So we can, instruct you in what we require as a company in order to do that. Because if you hold the property in a trust and you try to use a power of attorney, the trust may not allow for that to happen. So you could maybe not be able to use that power of attorney. The power of attorney may just be for personal things such as banking and not allow you to sell real estate. So it just depends on the power of attorney, how it's drawn up. So if you have one of those in your transaction, make sure that you are letting your escrow officer know. Also, mistakes in the recording of the legal documents. As a company, we make mistakes too. So if we record a document and it has a wrong legal description, things of that nature, then yes, we will make sure that it gets re-recorded at a cost of our company to get those documents recorded and the correct legal of record. Misinterpretation of wills. This is a tough one because typically we do not read the wills out and say, okay, Mom left you the property through a will, so we're just going to convey that property out. That's not going to be something we're going to do as a title company. What we're going to do is, if mom owns the property as an unmarried woman, or a married woman as her sole and separate property, and she passes away and she doesn't hold the property in a trust, then we're going to require that she have that property probated. And that's going to go in front of a judge. And then the judge will hear the case. He'll read the will and make a determination of who the property should go to. And then the court would issue a decree of distribution, showing where the property goes to, who the heir is, the name, as well as the legal description to the property. Depending on the worth of the property, you can do mini probates, which is letters testamentary, which is like not a full-blown probate, doesn't take as long, not as costly. So you can look into that, but I would suggest that you contact a real estate attorney for any type of questions on that. Another common title problem is deeds by minors. We come across every once in a while where mom and dad had a will, and they were horribly killed in a car wreck, and then it goes to probate and they leave their property to their minor child. Well, as a minor, you cannot deed out real estate property. You can't hold the interest because you're under the age of 18 years old. So typically what will happen is the court will say, okay, this is the minor that the property is to benefit, but they're going to name a guardian of that minor that will be the one to represent that minor in any type of transaction. And then it typically will have a date where when the minor becomes 18 years old, then the property automatically converts to them, and then they can sell the property if they like. Sometimes they set the age at 25. It just depends on how the court reads the will. So that's up to them. So those are some common title problems. Deeds by persons supposedly single, but in fact married. You know, I get a lot of, and I think this is funny, but I get a lot of times where they'll come into title on a piece of property as Darrin Nichols, a married man, or an unmarried man. And then, or let's go back. Let's say Darrin Nichols, a married man. And then when you say, okay, well, we're going to require that since you're a married man and your wife, California is a community interest state, your wife would have an interest in that, then we're going to require that she physically give you a deed, giving it to you as your married man, as your sole and separate property. And a lot of times they'll come back with, well, she's in India and I'm married in India, but I'm not married here. No, if you're married, I don't care where it is in the world, you're married, and that is it. You know, just because you didn't tie the knot in the United States of America does not mean you are not still married. And this happens all the time to us. So in that particular case, we would require that the wife go into the U.S. consulate in whatever country she's in and execute a grant deed to be forwarded back to escrow in order to give him the property of married man as a sole and separate. Because in California, it is a community property state. And since it is a community property state, what is mine is hers and what hers is mine. And if I come into title as a married man and I do not have some type of conveyance, a spouse making it my sole and separate property,
Doing well, Josh. How you doing today?
then, you know, we're going to require that deed happen. Under that, you have liens for unpaid estate, inheritance, income, or gift taxes, fraud in any type, pre and post policy protections. Alta homeowners policy has some post policy protection to it. Fraud would be one of them. Expanded access coverage in the homeowners policy. Restricted covenant violations. So if you own a piece of property, it has a covenant condition and restriction on it, and one of those may be that you can't have chickens. You know, I don't know what it is about today's society, but everybody wants to raise chickens. I don't know if it's the price of eggs. You know, it's like, oh, well, I got, you know, I'll get some chickens and I'll raise my own eggs and I'll put the chicken coop in the backyard with a couple of roosters. you may be in violation of your restrictions, because a lot of times those restrictions state that you can't have any birds or fowl on the property. So you could be in violation of those restrictions. So be careful. Make sure you're reading those. Building permit violations. A lot of times people will do add-ons to their home and they don't go get a permit. And they run their own electrical, plumbing, they put their own toilet in, so on and so forth. And then they sell it to this new home buyer, and that new home buyer, the house burns down, they go to get some type of permit to rebuild it, and they're like, oh, well, those weren't permitted, so you can't add that add-on back on. So, those are things that could be really a problem down the road for the buyer. Building permit violations typically will be shown of record if the county or city knows about them. Again, as a title company, we're only reporting what's public record. So if we didn't know about them because there was no violation recorded of record, then if there happens that they did do an add-on, maybe they closed the garage off and put a bedroom in there for mom, we would not be responsible for that because it's not made a public record. We didn't know about the violation and therefore cannot be held responsible for it. Another common title problem is subdivision law violations. Prior to 1972, you could split property just by deed with no problem. But after 1972, they enacted the Subdivision Map Act, which states that if you own a piece of property and you want to split it off, you have to go to the county or the city and apply for some type of lot line adjustment, parcel map waiver, or something stating that you can, in fact, split the property and sell it. There's a whole list of things that you have to do with the city or the county to do that. We look for those type of violations when we're writing the policy. If we see some type of deed in there where it's splitting a piece of property, let's say it's 20 acres and then mom and dad sold off 7 acres to their kids to build a house, and they just conveyed it to them by deed, they're in violation of the Subdivision Map Act. That would be shown on your report that we would require that certificate of compliance from the city or county be provided and recorded of record prior to closing our deal. Again, zoning law violations. This has to do with if you have some type of violation where you're in violation of what you can have on the property. If you're a single family residence, unless you are zoned to, you cannot operate a business through there. So those are some of the type of zoning law violations. Encroachment protections. We're going to find a record, typically through surveys, if your property encroaches or your building encroaches on your neighbor's property or a fence or vice versa, that policy does protect that. It is something that we are looking for. Water and mineral rights damage. This goes to do with ag land. If you have, let's say 100 trees out there that you're growing, and somebody has mineral rights and they're going to come in and dig up your trees in order to dig into the ground to grab the oil, gas, or mineral out of it, we do have protection against that. Supplemental tax liens, map inconsistencies, value added protection, and the list goes on. So there's many different types of problems that can go on, but our policies can cover a lot of those items with that new Alta homeowners policy. So make sure you're asking for that policy if you're a buyer's agent. This is what you really want to be using. It's a great policy to use. It really protects you as a buyer, your customer as a buyer. So don't let anybody ever tell you that it's optional. It is optional. You're not required to get a title insurance policy, but if you're a buyer, then I think it's a good idea to make that seller pay for that policy, since typically they're the ones who have to pay for it, and provide you with that policy, giving you good, clean title to your purchase, as well as listing any and all restrictions and easements, so you can be aware of any problems that you may be walking into down the road. I want to thank you for your time. I know I went through that very quickly. And I know this class will be recorded and you guys can go back and look at it, but if you can print that out and throw that into your briefcase or your desk, because, you know, hopefully using Chicago Title Company as your primary title insurance company, but maybe you know had no choice and you had to use one of the competitors. All preliminary reports are basically the same, shown in the same type of how they affect the property by recording order or how they tax wise. But if you get a report, then, you know, I think it's very important that if you're an agent and your buyer has questions, that you're able to answer some of them. Not that you have to be a title officer, because you can always refer them to us, but let's have a scenario. Everybody knows about Facebook, Instagram, TikTok, and all sorts of other things. Well, this is the way the life can go. If you're an agent and you're handling a transaction and your customer says, hey, you know, what is this? What is an easement? What's it do? If you have a general idea of what it does, not that you have to explain it completely, it makes you look way better in their eyes than if you just looked at them and said, I don't know. I don't know. Well, they're going to form an opinion of you. And with today's world of instant backlash and Facebook, it can go either this way. Man, I had a question from our real estate agent and they are really on top of it. You know, they were able to help me through the reading of the preliminary title report, and I would really suggest anybody buying a piece of property, use this guy, he's great, use this lady, she's great, so on and so forth. And then their friend likes it, and their friend likes it, and their friend likes it. Next thing you know, it's reached 15,000 people, right? And where your name's out there, and it's like, hey, this is a great person to use as an agent. Or it can go like this. I asked my real estate agent today a couple questions and they didn't know what they were doing. They didn't know how to answer it, just pushed me off, told me to go speak to somebody else. And then their friend likes it, and then their friend likes it. And so then the negative goes out. So I think it's just really important that you understand just the basis of a preliminary title report, what it does, you know, what the vesting is, what the legal description is. So you do come across questions like that, you're able to answer them, and just say, hey, this is what it does. But if you have any more questions, you know, let's contact the title officer, let's contact the escrow officer, and we'll get you a complete answer. You know, that's a lot better way of doing it than just look at them and going, I don't know. So I thank you for your time. I wish you guys the best of luck out there in today's market. And we hope to see you guys come in to Chicago Title and use our services many times through the years. Jen?
All right, I just want to thank you, Darrin, for doing an amazing job as always, covering all the issues in the prelim. We do have a brochure, Understanding the Prelim, that breaks things down along the lines of what Darrin shared, and we're happy to share that with you upon request. And this recording will be sent out to everyone who registered sometime later this afternoon. It will also be on our YouTube channel. So if you have someone in your office who can benefit from the information, don't hesitate to send them to the Chicago Title Fresno YouTube channel. Thank you again to everyone for taking the time out of your day to participate and learn with us today. We appreciate you, and we look forward to working with you on your next transaction. If there's any questions, you're welcome to stay, but this ends the official call.
Thank you.
See you, everybody.
Any questions out there for me, Jen? Are we the only ones left?
I'm not seeing anybody. So you did such a great job that no one had any questions.
Yeah, you know, we're the only ones on the call, right?
Not yet.
Not yet. Hang on.